Just for your information, Devin, this is Ben Szilagyi. We are on the record in the courtroom. The judge declined to have this conversation in a closed setting.
All right, and before we proceed about how what is going to happen with the public defender's representation in this matter, Mr. Flatoff, I guess I want to have a colloquy with you regarding your decision now to request public defender representation. Is that still your decision?
Yes, Your Honor.
And as I told you, when you waive your rights to a lawyer, you have a constitutional right to represent yourself, but you also have a constitutional right for representation by an attorney. You understand that?
Yes, Your Honor.
And you understand that you have to make this decision freely and voluntarily. Are you doing this?
Yes, sir.
Has anyone forced, coerced, or threatened you to make you waive your rights to represent yourself and request counsel now to do so?
No, sir.
I also need to... Can you hear me?
Yes, Your Honor.
Okay. I also need to know that you're doing this knowingly, and this is the big point I want to make with you, Mr. Flatoff. You've had numerous attorneys represent you in the past, and you've had concerns or issues with them and how they handled your case. Do you understand? If an attorney is appointed to represent you, then the attorney makes decisions on trial strategy and how to proceed. And so if an attorney is appointed to represent you, they may see things completely different than you see things and how you want to present your case. Do you understand that?
Yes, Your Honor.
That attorney is required to follow the attorney's ethical guidelines, and they cannot present evidence that's in violation of the Wisconsin rules of evidence. You understand that?
Yes, Your Honor.
And even though you may want to present evidence and witnesses in a certain way, certainly that attorney has to talk to you about it, discuss it with you, but it's that attorney's decision then to make whether they can present that evidence as they see ethically bound to do so. Do you understand that?
Yes, Your Honor.
So just like with these previous attorneys that were representing you, you of course are giving up some control here in how this case is presented. Do you understand?
Yes, Your Honor.
And whoever is appointed could take this case and say, you know, we're going to call some witnesses, not call some witnesses, rest. It's up to the attorney after consulting you to decide how they're going to proceed. Do you understand that, Mr. Flatoff?
Yes, Your Honor.
And if I would appoint, let me back up. Previously you said you would not accept any appointment from the public defender's office, but if I would order that should happen, you would accept an appointment from the public defender's office?
Yes, Your Honor.
And again, you're doing this freely and voluntarily.
Yes, Your Honor.
Okay, I will find that Mr. Flatoff has freely, voluntarily, intelligently waived his right to represent himself, and that he also has agreed to accept an appointment from the public defender's office. And so now, how to proceed with that issue? I understand we have, earlier this morning, we certainly put on the record some of the concerns that Mr. Szilagyi would have on how to proceed. And you know, the court recognized those concerns and put it off to this time so that he can consult who he needed to consult with and possibly have some other input from the public defender's office. Who will be speaking on behalf of the public defender's office today?
Well, Your Honor, I will start out. This is Mike Tobin. I'm the Deputy Public Defender, and just for the record, Ms. Bias had to leave this conference call for a previous meeting that she has, but I've consulted with her and her deputy and also our legal counsel and the regional supervisor in your area as well. So if we believe that it is within the court's discretion to, to make a finding as to whether, whether Mr. Flatoff can, reverse his earlier decision, but having reviewed at least pertinent parts of the previous transcript, when he made some accusation about his prior attorneys, we would attempt to appoint a lawyer, but we're not in a position to appoint a lawyer for him today. So if the court is in effect terminating the order for standby counsel and referring this matter for another public defender appointment. We will need time to do that, and given the history of the case and the issues, including, as I understand it, subpoenas for some of our staff that have been issued as witnesses, and what's already made of record concerning the previous attorney, I certainly cannot give any assurance that we would elect to appoint the present standby counsel as adversary counsel.
So I understand, Mr. Talbot, you'll have to react to my decision and proceed accordingly. However, what is your position that if I would order the Public Defender's Office to appoint counsel and I order that Mr. Szilagyi to do so? I understand your concerns. Number one, though, some of the staff that you mentioned, I did not authorize those subpoenas regarding the previous attorneys, specifically Mr. Haywood and Mr. Szilagyi. And I guess if you want to lay out the arguments regarding ethical concerns, you certainly can do that as well at this time, Mr. Talbot.
We would need to look into that, discuss that. If the court has the authority to make a county appointment, a dean appointment, and we're not taking any position at this point whether we would attempt to resist that in any legal means. But if the court is saying that under 977 you are now referring the matter to our agency for an appointment, we would not make that appointment in the middle of an ongoing trial any more than we would if there was a case in another branch that we hadn't been involved in. So, there's just too much history with this and what we believe to be legitimate causes for concern before we would be prepared to appoint at this time, particularly an attorney that specifically had been fired and discharged by the defendant.
All right. Mr. Flatoff, you understand, because of this position you put yourself in by waiving your right to attorney, firing some previous attorneys, including this one, that the options are limited as to who you're going to get to represent you. Do you understand that?
Yes, Your Honor.
And if the court would appoint Mr. Szilagyi to represent you, would you cooperate with his services?
Yes, Your Honor.
Are you willing to accept the appointment of Mr. Szilagyi as your attorney?
Yes, Your Honor.
And you would follow his legal advice and guidance?
Yes, Your Honor.
All right, Mr. Seaman, any thoughts?
The only thing, Your Honor, I feel comfortable with from a legal standpoint is the record made by the court in the history of this case regarding the defendant's waiver of his right to an attorney. And on the waiver of the right to attorney, since his change of heart this morning, I've not been aware of any new factor that's intervened during the course of his decision to go pro se approximately 2 months ago that would suddenly necessitate the need for the court to appoint counsel. There's been absolutely nothing that would that would be the equivalent of a new factor. I believe that this is actually a deliberate attempt on the defendant's part to thwart the state's case. He waited until the morning after I rested to do it. He didn't do it, didn't make this motion on after the first day or after the second day or after the third day. He waited to see all the state's evidence, to give it a test. He waited till it was in, and then it was time to start his case in chief. He's asking for a do-over. I believe it's an attempt to harass the victims in this case. I believe it's an attempt to harass the witnesses in this case to further push this matter off. Regarding the other area of law that I'm comfortable with is the record made by the court in finding that the defendant had forfeited his right to an attorney. And I believe the safest appellate issue, other than forcing or ordering somebody to pick up representation halfway through the first day of the defendant's case in chief, I think the safest issue is, and any review in court, I believe, would agree, is that this defendant has effectively forfeited his right to counsel. And if I had to make a wager, and I don't like to speculate on the record, but I think history has shown that whoever is appointed at some point, even if it would be Attorney Szilagyi right now, and we would continue, there would be some type of breakdown in communication between the defendant and even Attorney Szilagyi, probably before the close of business today.
All right, and any last words from Mr. Talbot?
Tobin, Your Honor.
Oh, what is it?
Tobin,
I guess Tobin?
correct.
Sorry about that. Mr. Tobin?
No, I think the record's, pretty clear, and it is the court's discretion how to proceed from here.
All right, thank you.
And we appreciate the contact both from Attorney Szilagyi and from the court to allow us to consider this matter.
Sure, and I appreciate your input. And so the court is weighing numerous factors in making this decision. I did previously find that Mr. Flatoff did freely, voluntarily, intelligently waived his rights to a lawyer. Above and beyond that, he affirmatively stated that he would not accept an appointment from the public defender's office. And so I found that he forfeited his right, because that's the procedure that's used to ensure indigent clients have representation. And so I did find that Mr. Flatoff gave up his right to attorney as his right to do so, and we proceeded accordingly. Throughout the many correspondence with Mr. Flatoff, from then till now, I let him know about his rights to recontact the public defender's office and see if they could represent him even at those late stages, and he continued to choose not to, and to represent himself. He certainly, throughout those process, continued to see the challenges of self-representation, specifically at some of the motion hearings, specifically the logistics of how to issue subpoenas and when to issue subpoenas. So he knew from initially that motion hearing until today's date all the challenges that come with self-representation. And now at this late stage, he now wants representation to do so, and the court will try to accommodate him. I'm also weighing the public defenders and Mr. Szilagyi's extreme concern here, and rightfully so, to being put back on this case in a late stage. He, Mr. Szilagyi, has ethical obligations that he needs to follow. He's going to possibly be appointed on a case that he had limited to no input as to trial strategy, as to subpoenaing of witnesses, the presentation of evidence, and made to really be put back in the game on the fourth quarter of a football game with many limitations. That is obvious for an attorney who gets put in at the end of, or at the close of state's case. I'm also weighing the victim's rights in this case. There's a constitutional amendment, Mr. Flatoff, that says the court has to weigh the victim's considerations and concerns and to prompt disposition of the matter. I'm recognizing the many adjournments that we've had here because of new counsel, and some not your fault, but some where you continue to not get along with your attorneys and wrote them some very disrespectful letters and made accusations, which caused this matter to be adjourned over and over again. And in fact, those concerns are laid out in this court's order for standby counsel, that why we needed Mr. Szilagyi or Mr. Haywood to represent him, because they seem to have a working relationship with Mr. Flatoff, certainly have been familiarized with this case to a certain degree, because they were on the case for several months before Mr. Flatoff then fired them as well. So this is not a perfect situation in any stretch of the imagination, and mostly it was created by Mr. Flatoff's decisions that has gotten us to this point. I'm not ready to go to the extent that Mr. Seaman is saying that it was a deliberate action. I guess I'm not certain. I don't know. I cannot read Mr. Flatoff's mind, but it does look like he did make a effort at presenting a case here with his questions and his preparation of the evidence and his preparation of the subpoenas as well as his summary. So if he wouldn't have made such an effort, I guess I would have questioned his state of sincerity of participating in this trial, but he did show some effort to the court as to that he tried this on his own, and certainly I saw his limitations and inability to present as maybe he thought he could. I will find, though, he certainly was competent enough to present himself. I mean, he was able to question witnesses, was very aware of the facts, and was able to address statements and videos and how to confront witnesses. I certainly felt he was lacking in the relevancy of some of his introduction, and we addressed that accordingly through objections in this court's rulings and some other findings the court has made. However, weighing all of these factors, including the defendant's right to counsel, the victim's right to have this case heard in a prompt manner, I am going to grant Mr. Flatoff's request for appointment of counsel. As been pointed out by Mr. Tobin, really Mr. Szilagyi isn't in court here today under a public defender's appointment. It's under a 977 appointment of standby counsel. And so procedurally, the court is not at this point ordering the public defenders to appoint a counsel. What the court is doing is ordering that Mr. Szilagyi to act as counsel for Mr. Flatoff at this time. I do believe I have that authority, reviewing some case law before coming to the court, specifically State v. Casey 175 with second 1 recognizes that procedure where standby counsel can be and has been ordered to step forward to act as counsel in this case, or in a case where there's issues with the defendant. It's not exactly on point. In those cases, the defendant became disruptive and was then standby counsel was ordered to represent him in his absence. So not exactly on point, but again, standing for the proposition that standby counsel can be then moved to adversary counsel. Also, Mayberry versus Pennsylvania, 400 U.S. 455, a 1971 Supreme Court case that again recognizes that procedure. And then one last case I reviewed was State versus Campbell 294 with second 100, where the role of standby counsel can vary from just being a warm body in the courtroom to at some point being adversary counsel if the situation's warranted. So under those case law, under section 977, the court does use its discretion to appoint Mr. Szilagyi as adversary counsel for Mr. Flatoff for the remaining portion of this trial. So with that, I know we have some procedural issues we need to deal with. Does Mr. Tobin wish to remain on this phone, on the line?
Yes, we will, Your Honor. Thank you.
All right, Mr. Szilagyi.
Your Honor, I guess I would ask for clarification is if this court is essentially ordering that the matter continue and that the trial not be adjourned.
Well, what's your motion? I guess that's what I'm asking.
Well, certainly. I suppose I was going to try to get clarification of the court's order before making a motion, but based on the court's prior order on the reconsideration of standby counsel, wherein it was my understanding that there were specifically enumerated duties that I was to have as standby counsel, and while I understand and agree with the court's point that there is a range of possibilities for standby counsel as far as duties and responsibilities, it was, I guess it would be my contention or my position that this court limited and narrowly prescribed the specific duties that I would perform as standby counsel, including, and I'm reading from the second page of this court's order, I believe it was filed on February 13th, that the court orders that the duties of standby counsel are to inform, and I guess I would stress that, inform Mr. Flatoff of the procedures and process of, and then it lists 5 separate issues. That, I suppose a big part of this, the problem that I see with continuing this trial today is that for the last 6 weeks or so that I have been relieved as my duty as adversary counsel and functioning as standby, I have not been making any effort to prepare a trial strategy, to prepare witnesses, to prepare a defense strategy. It's been my understanding that I would not have a say in any of that, but I would just be assisting Mr. Flatoff's directives. So I don't know that I am prepared to, well, let me rephrase that. I am not prepared to handle this matter in a way that I would view that would correspond to my ethical obligations to represent Mr. Flatoff. So I do think, although I understand all of the concerns of the state as far as witnesses that have been called and the length of time that we've spent on this, that I am duty bound to make a motion for a mistrial and that this trial be adjourned to allow me to prepare in a manner that is corresponding to my ethical obligations as counsel. And so that would be my motion at this point.
All right, thank you. Mr. Seaman?
Your Honor, the state would object to the defense motion for a mistrial. I certainly understand the reasons put forth. However, this isn't all about Mr. Flatoff. This is also about, for one, the state has a right to a fair trial. And the state would be prejudiced by a mistrial because the state's already exposed its trial strategy and has already put all of its evidence out there to be tested by the defendant, which the courts noted that he did test throughout the last 3 days. So there would be a prejudice against the state of Wisconsin. I do believe that ordering a mistrial would be contrary to the Wisconsin Constitution as it concerns victims' rights as well as the statutory rights that were enacted after that constitutional amendment. How many times I've subpoenaed the victims in this case for a jury trial, I couldn't tell. I don't know, 4 times, 5 times now. So to declare a mistrial, we would have to start that all over and put them through this again. The victim, Mr. Funk's daughter, testified yesterday. She's needing closure. I think I might have stated earlier on the record she had contacted me this morning wanting to know, to be notified when the jury got the verdict. There's so many other people negatively impacted by the defendant's poor choices, not only on December 5th, 2015, but at every step along the way of this hearing. The entire city of Neenah, large factions of Winnebago County, have been waiting for closure of this case, and to grant a mistrial would be contrary to basically the community as a whole as victims' rights are concerned, as well as Ryan Motorson, Michael Peterson, Stephen Arado, all the other people that have been victimized and been waiting for justice in this matter for nearly 2.5 years. Now for the defendant to say he wants an attorney to cause a mistrial after he failed to heed the court's warnings, numerous repeated warnings, that it's more difficult than he may believe. Just because now, with no other new factor presented, other than the defendant finally realizes this isn't like watching TV, so now he wants a lawyer to put all these people and all these victims through this again by declaring a mistrial, I think would be contrary to the Constitution of the state of Wisconsin, as well as the Victims' Rights Chapter, and I'd ask that the court deny the motion on those grounds, as well as prejudicial impact such a motion would have on the state of Wisconsin. And you set another court date, Judge, just like every time. I couldn't guarantee we'd get all these people here again. And we've gotten lucky every time this thing it's not been luck. Yeah, I'd ask to strike that. It's been a massive endeavor securing all these people for all these different jury trials that have been set here. and convincing them, you can't go to the training. Dennis Carroll is supposed to be in Las Vegas this week doing a training. Right now, Julie Whitrock, I have her charged with a number of felonies in a branch 2 case, is waiting for her jury trial in April because it was set for this week, and I convinced branch 2 to adjourn it to April because it was such a complicated case I couldn't hand it off to another attorney to prosecute. So the ramifications of the defendant's conduct are so far reaching, I can't, as I'm trying to articulate them, they keep popping into my head, the adjournments, the impact it's had on law enforcement, my office, the state, the people of Winnebago County. Therefore, I'd ask the court to deny this.
All right, so thank you. So as is put on this record, and it's crystal clear, I mean, we're in this situation because of Mr. Flatoff's own doing, his own decision-making, and, he certainly at the last minute realized he made some bad decisions, is reaching out for counsel, which might be one of his really best decisions he's made. But it is all Mr. Flatoff's doing that has got him in this position, and certainly I'm not gonna put off this trial when we're halfway through, considering all the implications of victim rights, as well as the interest of justice to get this case tried and completed within a reasonable time. We're already past that reasonable time. It's been 2.5 years since this incident. So this case needs to go forward. There's been nothing put forth in this record for a legal justification for a mistrial, and therefore I'm going to deny the defense request for a mistrial. Mr. Szilagyi, we will, of course, adjourn for the afternoon and reconvene tomorrow if you're ready to proceed. If you would like until Monday, we would adjourn this matter till Monday to start the jury trial. How would you like to proceed?
Your Honor, I guess if I could have a moment to think, I'm not sure. I know there are some witnesses here. And I guess I agree with the state to an extent that I don't want to.
All right, you want to recess to talk to whomever you need to talk to make the decision? How do you want to proceed?
Yes, Your Honor. I think I at least need to speak with Mr. Flatoff for, if I guess I could even have 10 minutes to talk to him about this.
Sure. All right, we will recess for 10 minutes. Let us know when you're ready. Please don't leave the courtroom with Mr. Flatoff. We need to make some decisions and figure out how we're proceeding before that happens. All right, Attorney Tobin, we're going to close now and I'll release you from the phone, okay?
Yes, thank you very much.
Sure, bye-bye.
Bye-bye.
Mr. Szilagyi is no longer standby counsel, but now represents Mr. Flatoff. The defendant's decision to represent himself and now to be represented by counsel must not influence your verdict in any way. Because of these changes of circumstances, at this point, the trial will be adjourned until tomorrow at 8 a.m. So at this point, I'm going to read to you your admonitions again, that you're to decide this case based solely on the evidence presented at trial and the law given to you. Anything you see outside the courtroom is not evidence. Do not begin your deliberations, discussions of this case until after the evidence is presented and I instructed you on the law. Do not discuss this case amongst yourselves or with anyone else until your final deliberation in the jury room. Do not research this case. Do not investigate the scene. Do not read newspaper articles or anything on or off the computer, dictionaries, websites, nothing. Do not seek information regarding public records. Any information you see outside the courtroom may be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you're serving as a juror. Do not permit anyone to communicate with you. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it's improper for them to influence your deliberations and decisions in this case. After this trial is completed, you are free to communicate with anyone in any manner. So at this point, the court is adjourned till tomorrow. Let's have you report at 8 a.m. downstairs outside of room 60. All rise and bring your notice. Mr. Seaman, anything further?
No, sir.
Mr. Szilagyi, anything further?
Your Honor, I guess just briefly, and this is more of a administrative matter, will the court be issuing a written order concerning my appointment as counsel?
I did not plan to. Did you want a written order?
I don't know if I need one. I guess I just was curious. And a separate question is, would the same terms as far as how the court would plan to reimburse the public defender's office for my time remain the same?
It is.
Thank you. Nothing further.
And Mr. Szilagyi, I know it's asking a lot, but are you going to be able, maybe by tomorrow, give us assessment on how many more witnesses or how we're going to proceed so we can give the...
I will do my best, Your Honor, and I hope to. I guess that's as best as I can advise the court.
All right, well, I'll at least put that out there that I would appreciate that, and I understand the challenges that you have. All right, that's it for today. See you tomorrow. We'll reconvene at 8:30.